All right, this is going to be part one of Class 8. Class 8 addresses two things: family protection and creations of trust. Creation of trust. We're going to cover part of family protection. Last Wednesday night was one of those times. It's happened probably, it happens once every 3 years or so where teaching life and working life don't intersect well and become a little bit of a train wreck. And that was Wednesday, so I should be good for a couple more years before that comes up again. Sorry about that. I would always try to make an effort to let you know before you get to class that that was going to happen. And I was optimistically hoping I was still going to make it, and it just became apparent at about 5:15 that it wasn't going to happen. So, family protection, we've I like giving these little context moments of where we are and why we are here. But we've gone through the whole gamut of our default rules when we don't plan. Our default rules apply sometimes when we do plan, but leave holes in the plan. Our default rules sometimes apply when we've got a good plan, but people die out of order, and we didn't address that in the documents, or property disappears, or something happens to it in everyday life and the documents don't address what happens to it. We have all those default rules in place. Then we've got a set of rules. How do we get around the default rules? All the formalities of a will. What does it take to have a will? How do you amend your will? How do you revoke your will? How do those things happen, accidentally sometimes? And what's the impact of that? But now we've got some more sets of rules on who do you have to provide for in your documents, and are there ways to limit provisions for folks. And one of the things I mentioned early on in class is a lot of clients always think that you have to leave something to kids, and for the most part, for 99.9% of the time, that's not true. It's easy to leave out your kids, with this little asterisk that as long as those kids are around at the time you do your will. It's a little more tricky to leave out kids that you have after you do a will because they weren't here when you were making your decision of who to put in, who to put out. And we'll talk about that in class this Wednesday. Um, Children that are born later after you do your will and what kind of rights do they have. Spouses, it is hard to disinherit. The theory is, marriage is a state law concept, and the theory is that when you pick somebody to be your spouse for life, then that comes with some certain legal responsibilities and legal effects of that joinder. And one of those is the assumption that you're going to leave that person something when you pass away. You don't have to leave them everything, but if you've picked this person to be your partner for life, you need to leave them something. Um, and so it is more difficult to disinherit a spouse. And and for this purpose, you're either married or you're not. You are married until the day the judge signs the order for the divorce, and then you're divorced. So it is a rather black and white thing. You can have a very unhappy marriage and a divorce proceeding pending for years, but you're still married. As far as if one of you dies, all the spousal rights come into play because you are married. Um, so the default rules for a spouse. Um, well, I guess first let's talk about different legal relationships of property between spouses. And there's two big picture legal relationships. One is common law marriage states, and the other one is community property marriage states. Community property marriage states, um, I will say, do have a little bit more complexity to their estate planning rules, both tax and non-tax, because each person, each the husband and the wife, or the husband, the wife, the wife, are all deemed to own essentially half of everything, regardless of how it's titled. And so, if you're deemed to own it, you kind of own it before and after the death of your spouse. That can be difficult when you're trying to do estate tax planning, where it depends on who owns the asset, who gives the asset, who dies with the asset. You have to take special steps to essentially sever community property sometimes. But in family protection, a lot of times it's not needed as much with community property states because um, each spouse is already deemed to own half. So it's not like you can disinherit your spouse if they already own half of it. Um, there is a concept called a widow's election at the bottom of page 255. And under that process, a surviving spouse can receive all income for life in exchange for relinquishing an ownership interest in his or her one half of the community property. So there are mechanisms in place where you can not the dying spouse does not have to leave his or her interest to the surviving spouse in the community property, but they might have to give an income interest in the property, income annually, income quarterly, some kind of financial benefit from the property in exchange for having the right to leave the dying person's half of the community property to somewhere else. Um, I don't spend a ton of time on community property either in this class or estate planning because it truly does require thought and careful attention when you're practicing in this area. But that's about as deep as we'll get. Community property, each spouse is deemed to own one half of the community property, and in order to get around sometimes leaving the dead spouse's interest in the community property to the surviving spouse, you can leave them something else like an income interest from the property. Also, do know with community property, not all property between the two spouses is community property. You might be moving from a non-community property state to a community property state. So, did the pre-owned property before you moved to the community property state, did that convert to community property? Maybe, sometimes it does, sometimes it doesn't. You might live in a community property state and then move to a non-community property state. Does that So then you're going to own both. You're going to own some community property together, and then you're going to have some non-community property owned as well. And the probate laws and the tax laws for those things differ depending on what type it is. Common law property, which is the bulk of most states, non-community property states. What they have is this concept called an elective share. And that is the surviving spouse's statutory right to the dead spouse's property. You are married to the dead spouse, therefore you're entitled to something, and it's hard to take that away from the surviving spouse. And so, if you are unhappily married, the dying spouse may do a will that leaves everything to the kids and say, I'm not going to leave anything to my spouse. And you can do that. Nothing prevents you from literally preparing a will that leaves everything to the kids. Where it can get a little bit tricky is if the surviving spouse kind of gets a second bite at the apple to say, am I going to let that happen, or am I going to take my statutory elective share right? And that's the uncertainty that the dying spouse kind of goes to the grave with. I can do a will, and I have clients that come in and say, we're separated. I want to leave everything to my kids. And I say, well, we can do that. I mean, that's easy to write the will to do that, but please know that at the end of the day, your spouse, your unhappily married spouse, really gets the chance to decide, is that going to be the estate plan or not? Or is he or she going to exercise his or her elective share to take their statutory share and let the balance pass to the kids? So this elective share concept, it's statutory, and it's in virtually I think this is a true statement, virtually all states except for Georgia. And that's not a big deal because Georgia has their own similar to elective share concept. They call it I think they call it spousal share in Georgia, but it's very similar to the elective share concept. And what that is um, you there's a couple things you have to look at to figure out what is the elective share. Um, a, a a person passes away, and we've already kind of learned this. If you've got your decedent, they've got a probate estate, and then they might also have non-probate property. And we've talked about what that is. Sometimes that's life insurance. That could be a 401k. that could be joint tenant with right of survivorship property. All of those things are passing somewhere regardless of what the will says. And the probate estate is passing through the will. Um, and because you can own two different types of property like that at death, the question becomes, what does your elective share apply to? Does it apply to just your probate property, or does it apply to your non-probate property? Because if you think about it, in cases where this can come up, and let's take an unhappy marriage where somebody's not wanting to leave their spouse all of their assets. In a very functional marriage, married couples say they leave everything to each other and then the kids, and this never comes up. In a marriage where something's not traditional, or something's not functional, or quite right, you've got somebody wanting to leave most or all of their assets to someone other than the spouse. And that's kind of easy to do by structuring stuff non-probate property. My life insurance to my kids, my 401k to my friend, maybe it's the special friend that broke up the marriage, my joint right of survivorship property to, the other joint tenant who is other than a spouse. And these are some big ticket items. Um, that can leave very little in the probate estate. The probate estate might be your bank account at the bank in your sole name, but that's easy to change. So maybe you put a joint owner on that too. It might be your stock account at Merrill Lynch, but that's easy to change. Maybe you put a joint owner on that too. And so there's very little passing through your probate estate. Um, there could be nothing passing through your probate estate, through to your will that leaves everything to the kids. So um, when this decedent dies and the spouse gets very little or nothing, if they live in a state that only applies the elective share to the probate estate, they're not going to receive much relief from an elective share statute. If they live in a state that applies the elective share statute to both probate and non-probate property, then they will get some relief because it's picking up these big ticket items, life insurance, 401k, and joint assets going to somebody other than a spouse. And arguably, you would say, I believe you would say this is the more modern approach because and the more modern approach is to have non-probate property that passes outside the will. So having a similar elective share statute picking up that stuff as well is helpful, is more akin to real life and picking up the assets. But top of page 258, know that there's first an analysis of, does your state's elective share statute pick up just this, or does it pick up everything? In figuring out what the calculation is. And the Thompson case on 259 is kind of a good example of that. You've got somebody who passed away and they have a rev trust, which we haven't talked about a ton, but a revocable trust is a form of non-probate property. It's this trust over here that owns assets that is payable to someone other than the spouse. And it's not the will, and so property is literally titled in this trust. And upon the decedent's death, that property passes to someone other than the spouse. It doesn't pass through the probate estate because it's already titled in the name of the revocable trust. Um, and that's what was happening in Thompson. You had assets in the Rev Trust, which were substantial, seven figures, and then you had assets in the estate that were not. They were not significant. And the trial court kind of went through everything and looked to see whether we should pick up both the probate estate and the Rev Trust for the elective share, or just the probate estate. And they went through and found that the Rev Trust should be picked up too and be part of the elective share calculation. Um, and so far, all we've really talked about is what goes into the calculation. We haven't even talked about what it is, or how it's calculated, or what it does at all. But a fundamental question is, you got to know what your base is. Where am I looking to see what assets are going to go into the calculation we're about to talk about? Probate, or probate and non-probate? It's I think this is a true statement. It's never going to be just non-probate. It's either going to be probate and non-probate together, or just probate assets. And if it's just probate assets, it's kind of easy to get around it. The UPC has an approach to figuring out the base. What do you pick up in your elective share statute? At the bottom of page 263, called this augmented estate concept, which is a more modern way to look at it. And that is you kind of look at the married couple, the husband and wife, kind of as a unit together. And what is their combined stuff, regardless of whose name it's in? What does their combined stuff add up to? And that's going to be our base in figuring out how much should the surviving spouse get. And so what they do is they page 264. There's a couple steps that are followed, and your book kind of explains this pretty easily. And that is, first, you value um, the decedent's net probate estate and the value of the decedent's non-probate transfers to persons other than the surviving spouse as well as to the surviving spouse. So non-probate transfers. You look at those two things together. And three, comparable assets that the surviving spouse would have been comparable assets from the surviving spouse that would have been part of the augmented estate had that spouse died first. So you might say the surviving spouse's probate and essentially non-probate assets. You add all those things up together, and that gives you an augmented estate concept. Augmented because you're augmenting the dead person's estate. You're augmenting it with non-probate transfers, and you're augmenting it with the surviving spouse's stuff as well. You're getting this big picture look at all of it. You add all those things up together, and so all we've done so far is figure out what's the base. What is all the stuff we're looking at to figure out what the share of the surviving spouse is going to be. And the second step on page 264, about midway down, is then you're going to apply a percentage to that. You're going to apply, so it's pretty, so far it's pretty simple math, addition and then multiplication. You're going to apply a percentage to that sum you come up with. And that percentage is going to be, it's going to be statutory, and it's going to change based on the time that you've been married together. The shorter the marriage, the lower the percentage. The longer the marriage, the higher the percentage. And let's see if they give you a couple examples. Married less than 1 year they just say a minimal amount. Spouses who have been married 15 years or more receiving a full elective share, or 50%. So the most a surviving spouse can get is 50%, and that kind of makes sense under the theory of there's two of us, so each of us can get is one half. If you're married 15 years or more, your surviving spouse is entitled to 50% of this sum of these three things together. And that's a pretty straightforward way to do it. It's a pretty inclusive way to do it, and in my opinion, a pretty modern way to do it. So once you figure out the amount, this is going to give you a number. What do you do then? How do you figure out, okay, I know what the number that my surviving spouse is supposed to get, but how do I get that number to him or her? How do I get those dollars to him or her? The last paragraph on 264, before you get to subsection C, kind of walks you through that. If the surviving spouse chooses the elective share, and let's kind of stop there for a second, it is called elective share because it's an election. The surviving spouse has to elect to take the elective share. I have had a couple situations where a decedent did not leave the elective share amount to the surviving spouse, and the surviving spouse didn't elect against the will to take his or her elective share. And one situation comes, you might say, why not? One situation comes to mind recently where this happened, and that is it was a late in life second marriage, and the husband died and the wife survived. Husband had adult sons from a previous marriage, and everybody got along fine. And it was just her understanding that that stuff that he had accumulated before their marriage was for his sons. And she was okay with that. He left her some stuff, and she had stuff from her prior marriage that she brought to the marriage. But she was okay with the idea that she wasn't going to take more than the understanding she had between her and her husband of what she was supposed to have. And that's fine. But there's uncertainty to that plan because she could change her mind after he dies, and there's nothing to stop her from getting her elective share. And it's not difficult to get. You don't have to fight for it. It's a statutory given. So, but so there are times where somebody doesn't get the elective share and they choose not to file for it. Um, but in a case where they do, how do you satisfy the amount? And that amount is satisfied first through the probate and non-probated transfers that do go to the surviving spouse, um, and things that the surviving spouse is already receiving. And if those things don't add up to the amount, then other, let's say, probate and non-probate transfers to others are proportionately used to make up the balance. So you look at what did everybody else, first you figure out, okay, what did I get and how close does that get me to my number I'm supposed to get? And if it's short, then I go look to see who are all the people that took property from the decedent, either under the will or through non-probate transfers. And everybody's going to proportionately divvy or pony up and give the surviving spouse their share. That is a little bit of a bumpy process because it could be a lot of people you're going to get property from, and you have to make them all part of the court proceeding if they don't want to, give up their stuff. And that can be a little bit of a bumpy process, but sometimes it's only one other person getting stuff, and so you just go get it from that person. Um, that's the augmented estate concept. You figure out the base, you apply your percentage, it gives you a number, and then there's a very clear way of how you go get it. The the non-augmented approach, I guess, the non-UPC approach, which means your state just has a statute. Um, you have to look at it state by state to see how it works. And in a Alabama's system, the way I explain it to clients, I call it the 1/3 rule. Alabama has obviously has a statute on point for this, and it's an elective share statute. And it has a formula that you run through to figure out what is the elective share, and you compare the decedent's stuff and the surviving spouse's stuff, and you figure out what actually went to the surviving spouse, and you figure out, and the way the formula works, it kind of depends who's richer. Um, if the if the poor spouse dies first, there's not going to be much of anything going to the rich spouse because you take into account his or her stuff also when you're applying our elective share statute, which makes sense. The elective share, the theory behind the elective share is your spouse needs help, your spouse needs support, and that's why you can't disinherit him or her. But if you're in a situation where the rich spouse lived and the poor spouse died, um, the theory behind the elective share doesn't make sense because they don't need the poor spouse's support. So, in our statute, which is similar to a lot of state statutes, takes that into account also. But when it does apply, when the rich spouse dies first and the poor spouse is the one that's surviving, so the statute is going to transfer something from A to B. It generally results in at least 1/3 of the dead spouse's stuff being part of the elective share over to the surviving spouse. So sometimes conversationally we call it the 1/3 rule. That is extreme oversimplification. And I'm not asking you to know Alabama statute. What I'm really asking you to know is a couple things. One, every state's statute could be a little bit different. And so you have to read the statute to know what it is in your state. But it's going to result in some assets mandatorily passing from the dead spouse to the surviving spouse if the surviving spouse is typically the poorer person, um, and your statute takes that into account, like ours does. Um, and so it's a very state by state rule and application of the rule. And then we've got our UPC approach, which is the augmented estate concept, which I think is probably the more modern way to do it. So spend some time on 264, kind of going through that and making sure you understand how that concept works. Is the elective share, is it, can you ever get around it? And you can. Otherwise, we wouldn't have prenuptial agreements. But you can waive the elective share because, and that's really where it comes into play is with prenuptial agreements. Prenuptial agreements address two ways that a marriage ends, and those two ways are death and divorce. And so with death, you have a married couple or an engaged couple getting married, and one of the spouses is trying to protect his or her assets and saying, I don't want to be required to leave the elective share to my spouse. I might choose to leave more than the elective share to my spouse, but I don't want to be required to do that. And that's when a prenup comes into play. And the only way to not be required to do that is essentially a prenuptial agreement where the where both spouses waive the elective share rights that he or she may have. Um, and I can speak to Alabama, but most states are like this. You can do that. There's nothing wrong with allowing an engaged couple to contract and make that agreement that they're going to waive the elective share for each other. But typically, you need to proceed in that way carefully and make sure everybody knows what's going on. And the formal words for that is on page 265. You can do it if the waiver is not unconscionable and you've got to have adequate knowledge of each other's financial status. So what good is a waiver of the elective share if you don't know what your elective share would be? So each party has to know the other party's assets, and the waiver of it can't be unconscionable. First part of that is, know each other's assets. That's kind of the easy part. Each party has an exhibit that lists all their assets and they share it with each other. You get a chance to ask questions about it. Has fair market values of real estate, investment accounts, cash, cars. If you own closely held businesses, you get the business appraised and there's an estimated value of the business on there. And so you share everything. I've had some clients come in for prenuptial agreements and I think a lot of people think that you can just get one real quick right before the wedding. And I have to explain to them, no, it's a pretty formal process. I'll represent you. Your fiance will also have to have a lawyer. In Alabama, each party needs a lawyer. And then we need to give them a very detailed financial statement of all your assets. Well, and they'll say, well, I don't want to tell them everything I own. And I said, well, if you want to get a prenuptial agreement, that's the only way you can do it. Each party has to have a lawyer, and you got to disclose everything. And you really have to disclose everything. Err on the side of over disclosure. If you leave something off your disclosure to each other, then the possible result is your prenup doesn't apply to what you didn't disclose because your soon to be spouse didn't waive his or her statutory rights to the non-disclosed asset because they didn't know you had that asset because you didn't disclose it. So it's a pretty formal process. It's a little bit time consuming and it's not inexpensive either because you've got two lawyers that are going to be negotiating back and forth. The second prong of what I said up there is it can't be unconscionable. What does that mean? That's one of those weird words in the legal world that could mean just about anything. Um, in other words, it needs to be fair. That doesn't answer the question. What does fair mean? What that's kind of been interpreted to mean, at least here in Alabama and in a lot of states, is that the process is fair. Nobody was asked to sign something the day before the wedding. It wasn't shoved in front of their face and kind of forced them to sign. There are cases where that was upheld. Um, and there was perhaps some negotiation back and forth. It wasn't a I'm rich, you get nothing of mine, and that's it. Although there are cases where those kind of agreements have stood up. Um, to find yourself in the category of being not unconscionable, most lawyers say, okay, if you're going to give up your elective share rights, if you're going to in this agreement, you're going to waive those, you kind of get something in return. I might give you a guaranteed life insurance benefit of 200,000 or a guaranteed life insurance benefit of 500,000, or that might be an amount that gets negotiated between the lawyers. I might give you the right to live in our, if I die first and I own the house, I might give you the right to live in the house for 36 months, and my estate will pay all expenses. But you give up all other rights to the elective share. Some kind of give and take um, is usually good evidence that the agreement is not unconscionable. Timing can be an issue. I like to say my rule is, and I break it all the time, but I like to say my rule is the prenuptial agreement gets signed before wedding invitations go out. And wedding invitations typically go out, I don't know, 6 weeks before a wedding. And so I like to have the agreement signed and done before invitations go out. Does that happen all the time? No. Usually somebody has in their mind they want a prenuptial agreement, but they're scared to bring it up until they feel like they have to. Then time is compressed. And I've had clients call me, I'm getting married next week, and I want a prenuptial agreement. Okay, well, tell me how y'all have talked about it. We haven't yet. I haven't told her anything about it yet, or I haven't told him anything about it yet. And I'll usually say, well, go have that conversation first. You need to let them know this is coming, then come see me, and we need to find him or her a lawyer, and they need to have time to go meet with that lawyer, and then we can really talk about getting an agreement. And usually it's too late, that close to the wedding. But there are cases where it's signed the day, 2 days before the wedding, and it holds up. Um, but you never want to be that case. You always want to be well ahead, make sure it's not unconscionable, and it's a fair disclosure of assets. The Shin case is kind of a good example of what not to do. I think he presented her a draft agreement the night before, um, or it was this one was 1 month, I think, before the wedding. Um, she met with a lawyer, I think that her spouse arranged, um, and the financial statement was not adequate. I think it gave a net worth of 853,000. In reality, his net worth was like 6 million. So it's riddled with holes in it. They're going to cause a problem. And he essentially ended up saying, sign it or there's not going to be a marriage. And so she signs it. Um, and and sometimes that is the underlying position. Sometimes somebody will say, you've known that I have to have a prenuptial agreement, and that's the only way I'm getting married. That's a little different than we're now engaged, and I'm not marrying you unless you sign this agreement. That those, maybe they're shades